Good morning.
Ready to started? Thank you for joining us today for another breakfast briefs. Before the pandemic, we used to do these fairly regularly, and then of course everything happened, and we tried to do it remotely, but now we're back to in person, so glad to see you be here. We will be having doing this more often. Our next breakfast briefs will probably be in the second quarter sometime, probably May, maybe June. The topic will be commercial real estate, so you can stay tuned for that. We'll be communicating that every able to finalize. Today we are going to talk about employment law issues. We have Steve Magala, the chair over here at Lavelle Law. He's going to be talking about updates to restrictive covenants. There's some changes in the law related to that. Maybe you may be involved with the non-competes, non-solicitations. So Steve's going to share specific details on that to help you govern whether or not these clauses are going to be enforceable. Second of all, we have Lance Evo. Lance is also a shareholder of Lavelle Law. He focuses his practice on litigation and labor and employment law issues. Lance is going to be speaking about mandate issues that are relevant out here today. Got a lot to say, I'm sure. And then I'm going to be talking about employee handbooks. So before we get started, though, a couple of minor housekeeping matters. Get to use the restroom outside there, on down to the right. Also, please help yourself to a breakfast. We all know breakfast is the most important meal of the day, so maybe grab a donut, coffee, get your day started. One other thing, we're not giving legal advice. This is more of an educational presentation here. If any of you have any issues you're dealing with that is related to today's topic, I encourage you to really reach out to us and for us to give legal advice that has to be tailored to your particular facts and circumstances. All right, so let's start. And then also, as far as the, we're going to give, each speaker is going to give about a 10 to 15 minutes presentation. If you have questions, please hold those until after this finish speaking. We'll give you an opportunity to ask questions. First, we're going to have Steve Magala talk about restrictive covenants.
Okay, work that. So, yeah, just right in the so kind of one real simple something that kind of defines the covenant.
It went away.
That defines what a covenant is. So, we'll talk a little bit about the part the existing law prior to the amendment of the Act. What the Act really does is it kind of codifies case law. You'll see that, but it also has something that goes to the law.
Oh, good. See,
All right, so if you do the work Act, it's only effective January 1st, 2022 for so anything after January 1st, 2022 is what it applies to. The existing covenant not to compete with your current employers, if I'm going to talk about that. Yeah. So, as I mentioned, recent amendments, they codify the requirements of case law, and they impose some additional requirements. So one of the things it does is it divides the covenant not to compete. It's really kind of a two-part alternative test. This is the first test here. If you satisfy one of these three factors, then you do cover with that definition. And the definition itself is pretty, it's kind of what you would expect. It's not even a shattered this definition. It's kind of what you would focus in see covenants. That's the first pass. The solution is the second one here. It's kind of a very similar one, which kind of like the first financial concept. I'm focusing on that. So if you satisfy one of these two tests, you're going to generally be satisfy the definition of covenant not to compete. Now there are some statutory exceptions in Section 5 of the Act. So a little bit of a quiz. You guys think of some covenants and constituency that would not really these exceptions. Exception. No. First one would be a covenant not to solicit, because they run the Act defines a covenant not to solicit. Another exception, this another definition of covenant not to compete is when there's a confidentiality application. Right, a lot of times you have an employment agreement with that requires full confidentiality, as well as non-compete the kind of solicitation provision. So confidentiality is not part of that definition for that. When you sell a business, oftentimes you're selling the will of the business. Oftentimes the buyer wants a covenant not to compete as part of that sale of the business. That is also the covenant not to compete under the act. So anytime you sell a business, you don't have to worry about complying with the extra provisions for these covenants. So let's look at some examples. The act also defines what a covenant not to solicit is. And here again, it's pretty standard definition. When we feed and collateral agreements to review, it's going to restrict the employee from doing two things: soliciting, for the employer's employees, and it's also going to restrict participation of the employer's clients, vendors, and things like that. And so, okay, these next two slides, for time, just kind of a summary of existing law prior to the amendment of the Act. We kind of get to that later on in additional slides because, again, the Act kind of codifies a lot of this stuff already. So let's do kind of these two slides. For this, read through these slides kind of on your own. You'll see kind of what the status of the covenant law was kind of prior to the Act. So, and a lot of the case law prior to the Act dealt with focus on the duration and geographic scope of the covenants and making sure that they were reasonable. So see a lot of the case law there focused on that. All right, as I mentioned, the Act codified by case law. So the general rule with respect to enforceability is the covenant is not to be enforceable unless it satisfies these requirements. And these are all the codifications law that was on the previous slides. So it's got to be added consideration. It's the employment relationship can't be greater than necessary to protect the employer. No undue hardship on the employee, not injury to the dollar. It seems that the lobbyists had their way when the legislature kind of enacted this act because there's a carve out for enforceability of covenants with respect to certain union employees, right? And certain construction employees, generally non-managerial construction employees, are not can't get those covenants enforced. All right, so there's also a definition of integration. So again, this is kind of codification of existing law that provides the talk about the past. That case established 2 years for continuous work for enforceability of the covenant going forward. So here the Act says, okay, it can be at least 2 years in executive agreement, or if the employer provides consideration when the restrictive covenant is entered into, then that's fine as well. And that's the case at a summary of existing law. Yeah. So, again, another summary of the case law that the Act is going to adopt. Reformation. The courts always had the ability to reform contracts or covenant pencil them and modify the covenants to make them maybe what the parties originally intended and the form of unflexible, reasonable forms. So the Act is kind of that's not what's new. That's really kind of over here. It's really kind of important. So there's certain salary thresholds here for non-compete agreements and for non-solicitation parties. So for non-competes, you have to have an employee who earns $75,000 per year. Those thresholds are 75 years. For non-solicitation, those thresholds are a little bit lower. Start out at 45, increase 75 to 2,500. And what does that $45,000 mean? What's this? Are you $75,000 mean? What does that mean? Base earnings, W compensation, salary, bonuses, commission, everything, plus budget referrals. That's not a There's also notice requirements. So I've been busy updating our agreements to pilot ownership companies. There's really two things you can consider here. First, you have to notify them in writing or enter into a non-compete access agreement. So we put that notice in our agreements. And then second, also in our agreements, that we have to give them these 14 days to review the agreement for the enforceable. They always have the option to sign before that. You have to at least allow for things. Another wrinkle here with respect to what the Act does is COVID-19 matters. If you enter into an agreement after 1/1/22, and then you terminate that employee due to COVID-19 or something, some similar pandemic, then you can't enforce that covenant unless you provide them compensation. That would be basically their base salary for the term of that restricted period, the duration of the covenant, last whatever the employee would earn during that duration period after they left your employment and took up employment somewhere else. So just as an example, if your enforcement period is 12 months, their base salary at the time of termination was $100,000. They go and then during that 12 months they earn 25 grand, then that's you get paid up to 75,000 or if that covered uniform. Another new wrinkle that the Act has with respect to new covenants is a fee shifting provision. So if the employee prevails, typically it's usually the employers and machines, right? Because they want to put a stop to the competition. But if the employee prevails in court, then there's a fee shifting provision here, so that the employer has to pay the employee's costs of the attorney's fees. So that's obviously new. That's something to support that operation. Just the bottom line, as an employer, make sure your covenants are reasonable, both in scope and duration. And then if you want to have those covenants be enforced, we recommend providing adequate consideration, which nobody really wants to wait in 2 years. So we would recommend in that case if you find bonus or something, for specific allocations, consideration allocate covenants. We need those agreements. Thanks.
Question. I've heard during the pandemic of people working at home to do multiple jobs. Is there any protection to employers that would prevent an employee from working 2 full-time jobs at home?
I think that's what the agreement says. So if there are covenants that each employer would oppose, look at the agreements and see that they can be reconciled or not.
Right. Is there a trend to have employees do something that says this is the only job we're doing?
We see restrictive covenants more so in like the higher positions like managerial. So that's where we find the covenants. So things like sales or C-suite members. So line level employees don't really see that as much. But yeah, I mean if you're somehow able to pull down to those managerial level jobs.
Well, I mean,
want to make sure.
I've heard stories of people taking 2 jobs, having their wife do the work, and then stays home with the kid, and then they go to the meetings, the Zoom meetings. They're like managing the job, having someone do it.
Well, that's probably not a good thing to do, right? Because that point expects you to be working.
Exactly.
It's not your spouse.
Exactly, but it's a new problem, I think, with not having to go in his office. To the office.
I would recommend it if you're
Sure.
Sure, go ahead.
So a lot of includes that language that the person has invoked their best efforts to the company.
Oh, okay.
That usually alleviate that problem. Also, generally, and it's not always the easiest thing to report, is employees do owe their employer duties of loyalty. So if they have a provision in their agreement that says they're going to give their best efforts, and they're getting paid for a 40-hour week. They're basically working 10 hours. They're probably not giving their best efforts. If they have language in their agreement about devoting their full-time effort to the company, there's potentially a claim against the employee for not being loyal to the company. Now, again, it's somewhat rare to see, but it's out there in a lot of agreements. That's standard language. You will devote your time and energy to the company. And if you're not, then there's probably a breach of the agreement. You know, the company can breach it with it.
Yeah, even without an agreement, breach of the fiduciary duty, employees have a duty of fiduciary duty with the employer to a certain extent, is that correct?
It's not a fiduciary duty. That's an elevated duty under the law, but it's more of a duty of loyalty and care, essentially. The courts do apply that violence. So I know it's out there, but you know, again, a lot of that can come in an agreement that says best efforts, time and energy. So. Sorry to have you up with this.
The new law doesn't really impact confidentiality provision, is that correct?
No, right, yeah, it's outreach laws.
You
It's just that piece and absences.
I mean, how effective, and Lance, you can jump into this, I mean, how effective do you think a confidentiality clause would be versus a non-compete as far as protecting the employer?
Yeah, I mean, there's standard parts of our employment agreements, as well as, you know, they're often just us, you know, agreements as well. You know, often the summary agreement that the employer with respect to confidentiality and assignment of IP, I think we have those developed by the they're very, very good things to have.
Does this apply to all sizes? So you work for yourself, it's higher.
I don't think, I don't think there's a size restriction to that with the definition of employer. The definition of employer, the act just refers to the wage and hour, minimum wage. So, under that statute, it's broadly interpreted, so like size of position.
Yeah, under the wage laws, base compensation, employees usually the way it draws compensation, kind of a basic distinction they make, but they don't limit it to size. We don't see size, which usually when you start getting into benefits, how you make that definitely. The rights act, those do tend to add size restrictions, but not if you're talking about wages, and since that appears to be what they alluded to, there wouldn't be a size restriction.
What about independent contractors? Why don't know?
No. Again, the employer employees, this is the one by reference to the wage law. That
So if you're an independent contractor, then you're back to the prior,
yeah, it's an existing law.
Yeah.
Which is, you know, if you go have a not be there, you know, it'd be good to try to just give things like cash.
So non-solicitation doesn't prohibit someone from coming to work for you who's under the salary threshold.
Well, if they're under the salary threshold, then it's not enforceable.
Right, so this may be an extreme case, but in today's world, we're very competitive out here now with companies trying to build our client base. So if somebody comes to work for me and they're under that threshold and they stay less than 2 years, they can leave, basically take this money.
Not necessarily. I'm sorry, I'm not speaking about the answer, but if you have a confidentiality agreement in place, no. Because generally your confidentiality agreement will cover customer lists, pricing, things of that nature, so no.
Remember, the non-solicit is very specific. The definition is they can't go out and actively contact these current clients or prospective clients and try to bring in the business. So what Lance is talking about is the actual list itself. They take that list from you. That's, you know, they're stealing your confidential information. It's a separate breach of confidentiality.
So the list is one thing, until.
Yes. Right.
but the challenge may be in proving, is this a trade secret, is this confidential information? That's for another challenge.
Yeah, I mean, applying this here. So yeah, I mean, but so the not solicited under 45 here right now will be enforceable, but if they did take like information, it's a separate covenant, not part of the act. So you But
So I should also prohibit the employees from sharing their cell phone numbers.
you want that to have, you want them to use their cell phone numbers through the course.
I mean, traditionally, no.
I mean, then you should have a policy that said, about your work number, you have that people contact with your work number, and you created a self-relation to services. And that could be part of the policy that you have.
Yeah.
Okay.
Thanks, Steve.
Yeah.
We're going to talk about what is a handbook, why have a handbook, also maybe some COVID policies that you may be considering, and then also we're going to talk about common handbook mistakes. First of all, what is an employee handbook? Well, it's a summary of policy, procedures, working conditions, expectations that will guide your employees' interactions in a workplace. It's important to note, if you're doing it properly, the employee handbook is not a contract. When you think about a contract, that is, parties having enforceable obligations. So with an employee handbook, what we try to do is we want you to make sure that the employer reserves rights to modify and change those policies from time to time. Otherwise, you may be faced with this breach of contract argument. So it's critical that you do it properly. You have the actual written reservation contained within the employee handbook. So why have a handbook? Well, a handbook is a good document to communicate to your workforce. You want to communicate to your employees the company mission. What is your goal as a company? What are you trying to accomplish? What are your values? What are the policies and procedures in the workforce? And what are your expectations of your employees? One phrase you hear quite a bit is company culture. What is culture? And a handbook is a good way to start with trying to define that culture. What does it mean to work for your entity? And with that handbook written properly, it's the beginning of trying to define that culture, which is really important today, especially when you start dealing with employee retention, employees leaving, going to other employers. Culture is getting more and more critical today. And then employee handbooks, or employee benefits, and keeps benefits. When you're negotiating with an employee, quite often, not an employee, prospective employee. A lot of times what happens, the potential employee wants to know, what are the benefits? What do you provide? And I think it's always nice to have a nice concise area in the handbook that defines what your benefits are. That way you can share that with other staff employees. So it's not a useful way to have the employee benefits written out in the handbook. Also, you want to try to limit liability as an employer. So it's important in your handbook that you identify and explain various laws that may be applicable in the workplace. In addition, you want to implement safety protocols. We're going to talk about that in a little bit. And this is really important. You want to establish complaint procedures for improper conduct. As you get larger as an employer, it becomes more and more difficult for you to observe and police your employees, and bad things could happen on the job site. And as an employer, you want to make sure your employees are protected, and therefore the handbook is a good way to lay out a complaint procedure. Another reason, you want to reduce the burden on human resources and increase efficiency. So what I mean by that, as you operate your business, you're going to encounter a number of scenarios, different, employee showing up late or violating this rule, et cetera, et cetera. Having a handbook with policies and procedures laid out makes it less difficult to deal with those scenarios. You know how we're going to handle this. You're going to think about it in advance, because sometimes these things come at you very quickly, and you want to react. Well, having a handbook in place, you've already thought this out in advance. You go to the handbook, you find out how you deal with the scenario. And again, it's impossible to cover every scenario, but there's a lot of common scenarios that take place, and the handbook is a good place to lay out those policies so you as an employer, you can anticipate and deal with these likely actions. Okay, what must be included in the handbook? When I say what must, it's not necessarily mandated by law, but as an attorney, we advise our clients to include these components in the handbook. At-will employment disclaimer. Does everybody know what at-will employment means? At-will employment. So it's important that that is, conveyed very clearly to your workforce. So you may have some workers in a different category, maybe under a set term, but more often than not, your employees are at-will employees. And handbook is a good way to reinforce that, so there's no confusion in the future in the event that you need to turn into. Employee acknowledgement of receipt of handbook. This is something that's really important that you have, because you're laying out all these policies, all these procedures, you're notifying employees of these rules in advance, and something may happen in the future where you have a disagreement with an employee, maybe you're in litigation with an employee or former employee, and invariably, after the last hears this all the time, employee claims, I never knew about this, I didn't know this was a policy, nobody told me this policy. So you have a nice signed acknowledgement from that employee, that will go a long way to defeat that argument and if you're faced. Anti-harassment policy, again, as you get larger, it's harder and harder to police your workforce. You want to lay out rules regarding harassment, prohibiting harassment. If you get into a harassment situation, it kind of goes beyond the scope of today's discussion, but as an employer, you want to make sure it's very clear that we prohibit this conduct and we lay out a good procedure to deal with it. If you have an employee who's dealing with harassment, you want to make sure they understand that, hey, you can come to me, you can report to me this problem and we'll deal with it. Because one of the, sexual harassment is hostile work environment, and part of that is, an employer maintaining an environment where the employee is dealing with harassment and you don't have a clear way for that employee to kind of deal with it and kind of report that wrongdoing. So a handbook is a good way to lay out the procedures so the employee who's dealing with that knows how to handle it. And then anti-discrimination policy, again, it's important it's in the policy that everybody understands that you're an equal opportunity employer. Reasonable accommodations, this is something that comes up from time to time. Employee is a disabled individual, has a disability. You want to make sure there's a procedure in place for that employee to communicate that to the employer, because if the employer is subject to that, they have to provide reasonable accommodations to that worker. And you don't want to face a situation that I didn't know how to communicate that, or I did notify you, I told you I had this disability, but you never accommodated me. If you got a procedure laid out in black and white how this is supposed to happen, and if they didn't follow that, then again, that helps you as an employer to defend if you're facing that argument. Employee classifications, as I mentioned before, most people are out of employed, but you may have a different category of employees, they fit in a different benefits, different obligations. And as I mentioned before, employee benefits. Also, as I said in the handbook, is business hours schedule. When are you open for business? Because again, sometimes you deal with employees showing up at different hours. You want to make it clear, this is when we're open for business. This is when we need to be here. Now you may have specific time frames for each particular employee, but generally it's a good idea to have that in writing what our normal schedule is for coming to work. And then paid time off. If you're going to provide paid time off, how many days are given? What about holidays? All that should be laid out in the employee. COVID. Okay, so COVID is something that's here for the last few years, and as employers, you're bombarded with what you want to do. You got guidelines from the CDC, you got guidelines from IDPA, Cook County, everybody that's coming out with these different guidelines. What do you do as an employer? Well, first of all, employers do have an obligation to provide a healthy and safe work environment for their employees. So if you as an employer, you want to deal with COVID, you can certainly do that. Now there are certain employers that are required to provide COVID policy. If you're a Medicare provider, for example, you are obligated to have a COVID policy. If you are going to do that, though, I think you need to have this policy in writing. Whether you want to update your handbook or you want to have a separate writer, you should have that policy laid out in writing. Now, your COVID policy, if you're going to have a policy such as you're going to require vaccination, you're going to want to have exemptions for medical reasons, exemptions for religious reasons. Implementation of these exemptions has to be, you want it in writing, and you also want it to be done consistently, okay? Because what problem you can have if you have worker A, you like that worker, great worker, shows up on time, does great work. Worker B, not very good, shows up late. Maybe I don't like this worker, okay? They both claim a religious exemption, okay? You may feel, I'm gonna give it to this person because I like this guy, this person you don't. You gotta be very careful with that, okay? Because then when you decide I'm gonna let this person go, you may be facing a discrimination situation. If this person is a member of a protected class, they may come back and argue that I was treated differently because of my membership of that class. So it's important that these policies are implemented consistently. Common handbook mistakes. Well, first of all, the biggest mistake that we see quite a bit is companies who feel that they can just go on the internet, go on Google, do a search for employee handbook, stumble upon a book, oh, this looks good, print it up, throw the name on the top of it, boom, I got an employee handbook, okay? Very dangerous, very risky, because that handbook that you found could be tailored to a particular industry, a particular business. There could be different rights and benefits given that you may not be wanting to provide. So there could be some ambiguities in that. One thing when you draft a good handbook, you want it to be very crystal clear as what your policy and procedure is. Who knows who drafted this handbook online, if it's unclear and ambiguous, you just be creating a situation where it's just ripe for litigation. Another handbook mistake, failing to get handbook acknowledgments from all employees. You should have a policy when a new worker comes in, first day on the job, you should have a nice intake policy where, okay, you have your tax forms you got to fill out, maybe other information that you get from the worker. Employee handbook should be the next thing right there. And it should be handed to the employee. The employee should sign an acknowledgement right then and there on the spot, and then you should get it scanned and saved to the server. So if you ever need it, you know where to find it. Because a lot of times things happen fast, you always intend that I want to get that signed, and you just never get around to doing it, and then you got a problem. Another common handbook mistake, failing to enforce or follow your own policies. This gets to the consistency. If you don't always follow that handbook on a consistent basis, you may be faced with a claim for discrimination. Maybe that's not what you're doing, but it can be used as an argument against you. So you want to make sure you're following your policies in a consistent manner. Drafting policies that are too vague to enforce or complicated to understand. Again, that handbook should be concise, it should be very clear, very readable, so when you pull it out, you understand what it means, what those policies mean. Next, assuming the handbook you put in place years ago is still good. Okay, as you grow as an employer, you may want to deal with situations differently. So you always want to revisit that handbook from time to time and make sure it still applies. Okay, and as I said before, you want to reserve that right as an employer to modify that handbook from time to time. And then finally, not involving an attorney. Again, it's risky to just pull up a handbook online or draft it up yourself. I mean, you may know what you mean, and however you may put something in there that runs afoul of the law or creates an ambiguity that an attorney can kind of identify and see right away and say, hey, this could be a potential problem. You should avoid this sort of language. Any questions on handbooks?
Well, Ted, in the past, a handbook used to be a physical book. A lot of times, it's not live. You made some changes to your handbook, sending out an email to all your employees. Would it be enough to let them know that they even told you about these changes, or unless, of course, it's a major change on the side?
Yeah.
Protection out for your company saying, hey, we made a change to this, this, and this, in an email to send out to them.
Yeah, I think the question, it's a good question to raise. Again, the scenario is you make a change in the handbook. you have a problem with an employee later on, you want to terminate them, and they raise some issue that, you know, you didn't follow the handbook, I didn't know this was the rule. So how do you determine and prove that they had notice? If sending out an email notice, I think is pretty good. On the other hand, if it's a major critical change and you want to make sure there's no confusion that you knew about this change, that's where you may want them to sign a new acknowledgement, email it back to you, put it in the employee file.
So how often should clients review their handbooks?
Well, I would say every 3 to 4 years, you should always revisit it, or if you have just some major change in your operation, or if there's a new change in the law, I think, you know, that comes from time to time, you want to revisit it at that point as well. So there's really no hard and fast rule, but again, as a prudent employer, you should always, you know, revisit those policies every 3 or 4 years.
Recommend we have annual attestations and just at the time it's updated.
I would think every time there's an update, I mean, I don't know if it's necessary to have it every year. If there's no changes, you have the acknowledgement already, so you have it already saved that there are no changes, so it should be good there. Yeah, every time it's a major update, it handbooks.
Does it make sense when you update a certain policy that's inside the handbook that the physical, I mean, obviously you update the whole handbook, but
Yeah.
yeah, I'm just thinking about the efficiency piece. So if it goes into your HRIS, right, and you have your employees acknowledge it that way, do you have them acknowledge again the entire handbook, pointing them to that one policy change, or do you update just the policy and have the acknowledgement on that? And obviously on the back end, you still are updating the whole handbook. Does that make sense?
Yeah, I mean, well, today, more and more, as you mentioned, these handbooks can just be online,
Right.
or the PDF that you circulate. You know, back in the day, you had a physical handbook that you would hand out to them. You got to reprint it, you know, 100 workers, and you know. But now it's just all PDF. I don't know if it makes, you know. I think any way you can kind of demonstrate that this person has knowledge and notice of the change and the update, getting them to sign something, you know, I think it's pretty easy to just go ahead and have them sign something and you know, go ahead and the whole handbook.
The whole.
Yeah.
So this is going to be not even a 10,000 foot view, this is more like 100,000 foot view of this. And the reason for that is it's changing every day. I know way more about it than I ever dreamed I would want to know about it. I could hijack this whole meeting into probably a half-day seminar on this. So I'm going to really touch on things that are more relevant to employers. And then I'll open it up to questions, which I may or may not regret at this point. So the big thing this past year or two has obviously been the masking and the vaccine mandates. And last year, President Biden tried to work through OSHA to get the emergency rules requiring private employers over 100 employees to require vaccinations. How many of you guys have over 100 employees? Okay, so you would have been subject to this. So that was stayed essentially stricken down to the PRO by the Supreme Court. Now, there's a couple of interesting points about that. Well, first, there's no federal vaccine mandate for anybody over 100 employees. Second, the interesting thing to note about that is it was a TRO. So that case hasn't been decided on the merits yet. Meaning this was all very preliminary. The court said you can't do this. It's questionable whether this is legally enforceable. There would be irreparable harm under the law. Therefore, we're not going to let you implement this at this time, but we're not going to speak to whether legally you can do this. So that case is still out. It hasn't been decided. In any event, they withdrew the emergency rule, and now OSHA has indicated that it may try to pass the same rule but go through the regular rulemaking process. There are essentially two ways to make rules. One's an emergency, which is done here. Basically, we're going to bypass public comment. We're going to bypass people having input on this and things like that. And then there's a regular rulemaking process. And this is applicable across pretty much every administrative agency where the public has comments. So chambers of commerce would weigh in, unions might weigh in, different people would weigh in, submit comments, they take all of this into account, and then they either pass the rule or they don't pass the rule. So that this may still happen. If it does and they submit the rule, it's going to go through the regular rulemaking process. There would be a lot of input. They haven't actually filed that rule as of yet, not that I'm aware. it could happen. But as of now, it's gone. There is talk that they're going to try and put this in again. In that same Supreme Court decision, they did not stay the Center for Medicaid Services emergency rule to require vaccination of healthcare workers employed by employers who participate in Medicare and Medicaid programs, including their providers and suppliers, which was kind of interesting, actually. So the distinction the Supreme Court made here was that, OSHA, it's not really your business to go in and tell these private companies what they can and cannot do with their employees. You're overreaching there, this rule is just going too far. However, if a private employer is getting money from the government, then you have a vested interest in what's going on there, so we are going to allow it there. Now, why they included the providers and suppliers, not really sure. I think this would just apply more to hospitals and its employees, but they stretched it a little bit further. So that is in effect at the present time. That rule will expire at some point. Emergency rules have a kind of a shelf life to them. I would assume at some point they're going to pass a rule that makes that permanent. Now, there's two different dates that this went into effect. There were states that had filed suit against the government and lower courts had granted a stay. So there were later dates for them to implement this. Then there were states that did not have stay in effect. Illinois happened to be one of them. So it went into effect earlier for those states. The other big executive order, and I don't know if this will apply to anybody here, was they had, there was an order requiring all federal workers and contractors, and then it went farther, including employees working on or in connection with covered federal government and subcontracts to have vaccinations. That was also stayed, so there's no federal mandate for these employers or employees. Again, they have not stated whether they're going to re-implement or try and repass this order or rule through some other method. In the lovely state of Illinois, there is also an vaccine mandate pursuant to executive order, but it's limited to certain employers and employees. So you have healthcare workers, school personnel, although that's somewhat challenged at this point, higher education personnel and students, college, state employees and contractors who work at state-owned or operated congregate facilities. If you think about that, that's nursing centers, things of that nature. The school personnel piece right now is partially blocked. There is a TRO in effect right now as to, I think it's 140 some odd school districts that did cover teachers. So in those districts, you have to get court orders to require. There's no federal mask mandate. There is, however, there's two rules. One of them is not on there. I looked it up later. Transportation security requires masks across all transportation networks. The CDC also has an order in place that's similar to public transportation. So it's a little broader in that sense. And then masks are required presently in most federal facilities. Going to federal court, you have to wear masks. Which is why most of that all done wrong. So, the state mask mandate. That's ending February 28th. Obviously, that's kind of at the governor's whim. He may reinstate it. Masks are still required in schools. Again, limited now to the TRO in place. Daycare facilities, healthcare facilities, congregate care facilities, businesses that require masking, cities or municipalities require masking, long-term care facilities in communal areas and public transportation. Again, in schools right now, that's challenged, 140 schools. School districts, that does not apply. And the last time I checked, 708 of 800 and some odd school districts in the state of Illinois are mask optional, so far exceeding what the policy would allow. How many of you have businesses in Cook County? The proof of vaccination requirement is going away. That's cabinet this month. That is nice. So, questions? Good, no questions.
Let's talk about the current status of the cases in the school districts.
I mean, without being too personal, these guys have people in school. It's okay. How many of you have been following this lawsuit? So, I'll start here. I filed the next lawsuit 2020. Lost the TRO. I think it was too early in the process. It was probably too much of a crisis at that point to have the court give you the relief on it. Tom DeBoer from downstate filed some suits, and obviously, it was probably a month ago now that TRO was entered, and I think the timing on it was better.
Also a different county as well.
Yeah.
It was different county, same judge though, because all of the cases across Illinois, there were 6 or 7 of them, got consolidated into my case in front of the same judge. So he succeeded where I failed. I actually talked to Tom Locke quite a bit. That case went up on appeal to the 4th district.
It's the Sangamon County, right?
It's Sangamon County, and the 4th district covers a lot of central Illinois, Springfield, some other counties. That case went up on appeal. I wrote 80% of the appellate brief in that case. The appellate court dismissed the appeal as moot. It was an interesting ruling. Their logic was interesting, and some of the things they said in their order were interesting. Yesterday, the governor filed a petition for leave to appeal to the Illinois Supreme Court. I assume that will be granted. They also requested an expedited briefing schedule. I've heard they filed a motion to stay. I have not personally seen that. I did see the leave to appeal because I'm on the service list. I did see motion to expedite. If the court grants the motion to expedite, a response would be due sometime next week, I believe. I haven't talked to town about how much, if any, involvement I'll have in writing the appeal. With possible oral arguments set at the end of March, week of March 20th, I believe. Again, I haven't talked about who's going to do oral argument or what my involvement is going to be. There are a lot of open questions, really, based on what's happened so far. The way Judge Grisham, who's the judge in Sangamon, wrote the order was less than ideal. And I think it created a lot of chaos in the state in terms of what school districts could and could not do. The appeal honestly didn't do any better, to be honest. The opinion was, it left a lot of questions open that I think the state defendants, meaning the governor, the Department of Public Health, and the State Board of Education, raised before the Supreme Court, which is why I think the Supreme Court will ultimately take it. I think there's some very important issues still out there. But we'll see what happens. That's kind of the current status. I think a lot of school districts have gone mask optional at this point.
Hey Lance, some school districts have kind of made an argument that if you're not a party to this particular lawsuit, the rulings don't apply to this particular child. I mean, is there a benefit for families trying to join and become a party to this lawsuit? Is it too late for that, or is that something that they should be considering if they're interested?
I know Tom DeVore filed a lot of motions for joinder. The only reason I know is I have to get copies of everything that's filed, so I've seen probably a few hundred of these things get filed. The interesting thing about what happened in the circuit court was the real problem schools had, or the real problem families had, I guess is better to put it, was last year the Department of Public Health changed their rules. And within the rules, there are definitions for things called quarantine and modified quarantine. Quarantine, obviously, kind of obviously, you're telling somebody they have to separate themselves, stay at home from school, they have COVID, or did a close contact, or things like that. There's also a term in there called quarantine modified, which essentially covered requiring people to wear masks, test, things of that nature. And under the Department of Public Health Act, this is how some lawsuits were won previously, in order to quarantine anybody, including a modified quarantine, you got to get a court order. So what they did was they changed the rules, they struck out modified quarantine, changed the definition of quarantine, and permitted schools to exclude children as opposed to quarantine or isolate them as a way to kind of run a end around the rule of law. Judge Grishow struck those rules as being a nullity, so essentially they didn't exist anymore. The Department of Public Health tried to refile that emergency rule and was not able to. They have to get approval from a commission of, I believe it's 9 individuals that are from the legislature, both parties, and I believe it went down 9-0 that they didn't pass the rule because it was up on appeal and district. That was kind of the linchpin to a lot of this stuff. So to answer your question directly, could it benefit somebody? Yes, if you're one of those school districts. To the extent the school district is saying, well, we're only going to do the main plaintiffs. If you really wanted to fight it out individually, no. Realistically, that rule is gone. So whether you are a party to this lawsuit or not, the law is you have to get a court order to mask quarantine, exclude a child from school. Now again, this is all being litigated. The state's position is the governor can do all of this, change the rules through his executive orders. He doesn't need to follow the Department of Public Health Act. And that's an issue that's up on appeal. So what that ends up being at the end of the day is an open question. But could it benefit somebody? Certainly, it really depends on the school district, to be honest. Bearing in mind that 700 and some odd school districts are no mask optional out of 800 and some. It really just depends on what your school district's doing if they're part of the lawsuit.
So if my kids are both in the lawsuit, not named, but they're districts in the original one. So is there any benefit to becoming part of the joiner? Because although they're not named specifically, their districts are. So where does the difference sort of lie? And is there any benefit for us joining that because they are not specifically named? Even though our districts are,
Your district was.
I'm 25 and 214.
So it really depends what your district is doing now. If your district, again, a lot of them have gone mask optional, if your district is still requiring masks, and they're saying we will only honor people that are in this lawsuit, then it would benefit you. Now again, really wanted to fight them about it, doesn't really matter because the rule was stricken. That applies to everybody. It's not just people in the lawsuit. The rule's gone, so.
Yeah, they applied it very broadly to all, both districts are optional.
So it wouldn't really benefit you at this point because the school district already did kind of.
Well, I guess I'm thinking if the Supreme Court says, yes, he has this power, he says, great, now we all have to mask. That would only the kids who were specifically named would be optional. I guess that's what I'm.
Yeah, I think.
Happening.
If the Supreme Court were to say, the governor has the power to do this, I suspect that TRO would then fall away. Temporary restraining order.
it would follow for everyone.
I mean, realistically, that was the basis of her order was twofold. It was number one, these rules are invalid, therefore they're gone. Part two was the school districts cannot enforce the governor's executive orders as they relate to masking, testing, and vaccination. So if the Supreme Court were to say, well, the governor does have this authority, I assume as part of that ruling, would be that the TRO would fall at that point, and then you'd have probably a whole other set of litigation happen after that.
Okay, I wanna, in the interest of time, I know everybody has a very busy day, so I wanna, if you have other individual questions, I would always encourage you to reach out to Lance or Steve or myself. TRO is a temporary restraining order. Most litigation attorneys are trying to fight about money, but a TRO, we're asking a court to order somebody or some entity to do something. And that's what a TRO stands for. We're asking a judge to order somebody to do something as opposed to money.
Yeah, and let me, before Ted closes you out, kind of like I explained at the beginning, lawsuits have kind of a process to them. So you have the merits of the case, which is generally complaint. You did this bad thing under the law. But, so I don't get hurt further, I want you to stop doing it now before we decide whether I'm really right. And that's what a TRO does. And again, probably the easiest place for me to, give you an analogy is non-competes, non-solicits.
Where damages may not be sufficient to remedy the problem.
It's the ongoing bad conduct that you want to stop. You want to stop it now before it's ruined.
So one other thing before I let you go, April 7th, Lavelle Law is having its business after hours, so everybody please look for that. It's a great event, good place to network. We'll have hors d'oeuvres, appetizers, drinks, and some more networking. And I don't know if we're gonna have a baseball season or not, but it's a baseball theme after hours. So hopefully you can join us for that April 7th. And with that being said, thank you for coming and have a great rest of your day.
Thank you.
Thank you.